Welcome back. So I'm just going to share screen now. Let me just manage all participants. I'm going to mute everyone. Okay, so share screen. Okay, so tonight we will further discuss the principle about judicial powers and focusing on the prohibitions and the exceptions. This is an important topic because whilst we have discussed the Boilermakers case in the past, there are certain exceptions and prohibitions actually that we will examine in the course of this tutorial. And so questions like, if we say, for example, that under the Boilermakers case, it is impermissible for non-judicial power to be vested in Chapter 3 courts. What happens when a law does invest or does vest non-judicial power on a Chapter 3 court? Will it mean that that would be invalid according to the Boilermakers case? So for example, I'll give you an example. I'm not really sure if even it's part of the, it probably is part of the tutorial question, but I'm just going to extend it shortly. For example, what would make a, what can constitute a non-judicial power would be when the law provides, for example, that a judge can issue an order as she sees fit, or whatever may be expedient according to the requirements of the case. That is an example of a non-judicial power because it doesn't use legal standards. So when the standard is as he sees fit, or according to what is expedient, or that the judge can use discretion, because those don't use legal standards, that is an example of the exercise of non-judicial power. In fact, those kinds of formulations are actually the ones that are used by, I'm just gonna raise the chat so I don't miss anything. Those are the kind of directives that are in a statute that are directed to administrative decision makers, or what are known as, non-judicial officers. And so, if you have a scenario where that is vested in a Chapter 3 court, will it mean that the law is invalid? So that is an example of why this particular topic may be crucial. And so we will examine that in the course of tonight's tutorial. Because for some of you, I think, I'm not sure, you'd be lucky if you haven't gone through it, but for some of those who've had to go through the unfortunate process of being before the Federal Circuit Court, or probably the family court, in relation, for example, to matrimonial disputes involving divorce, involving custody of children, you will realize that sometimes there are instances when it will be the registrar who will be making orders in behalf of the court. And so, and this is related to the first example I gave. And so in that case, if the registrar acts in behalf of the court, will that violate the Boilermakers case, in the sense that that might be an instance when judicial power is not vested in a Chapter 3 court, because a registrar formally is not really a part of the Chapter 3 court, because the registrar is not a judge who is protected, for example, by security of tenure. So would that mean that, if judicial power is vested in the registrar, that would be a violation of the Boilermakers case, which is different from the question I asked earlier, when certain non-judicial powers may be vested in judges of Chapter 3 courts. And for those of you who've been through divorce and been involved in a child custody case like I have been, then you begin to wonder, is it actually permissible for the registrar to be doing this? And so on. But that is the state of the law, and you begin to wonder, is that constitutional? Is that valid? So these are part of the questions that we discuss in tonight's tutorial. So after studying this topic, you should be able to discuss and explain the prohibitions and the vesting of judicial power in federal and state courts. You should also be able to distinguish and explain privative and loudspeaker clauses and their validity, and cite and discuss key judicial decisions that elaborate on the prohibitions, the vesting of judicial power in federal and state courts. In addition, so actually, if you go through this particular topic, it can really get all so confusing, okay? And I wish to emphasize that because if you read the book by Ratnapal and Crow, they often take a very critical stance, not just them, but a lot of other constitutional law scholars often take a very critical stance of the way that the High Court approaches constitutional law cases, because they sometimes feel that the High Court arrives at decisions on the basis of what is expedient, even if theoretically they don't seem to be very sound from the viewpoint of constitutional law. Now, we're not going to go into those arguments because that's not right for a year one course, but it just suggests that because in a way there is an exception to an exception that the High Court recognizes sometimes, you begin to wonder, what is the basis for the High Court arriving at that decision, and hence the reason why a lot of constitutional law scholars become very critical. But at the end of the day, what the High Court says is the law of the land. So we just focus on what they say is the law. Part of the questions you'll probably be asking tonight as well is in relation to military tribunals, which exercise judicial power, and yet the military tribunals typically are not organized as Chapter 3 courts, or according to the Chapter 3 of the Constitution. How is that even possible? So for those of you who are in the military, there are military tribunals there which try the members of the defense force for crimes and for issues about discipline. And they've got their own hierarchy as far as appeals and reviews of decisions are concerned. So there is judicial power that is involved. Judicial power, in fact, that can be argued to be of the Commonwealth. And yet, judges of military tribunals have not been appointed by the Governor General in Council according to the requirements of Chapter 3. So does it mean that military tribunals are unconstitutional? So these are just some of the questions that we will be discussing tonight. Now, this one, so we have about 5 questions tonight, and probably, So this one should be quick and easy. I'm just going to read it myself, and then, you can tell me what the answer should be. But this is just kind of an introductory quick question. So the Governor General appointed a prominent and highly respected lawyer as acting justice of the High Court to take the place of one of the justices who has been on prolonged leave due to a debilitating illness. Rule on the legality of such appointment. Any volunteers? Is that legal or not?
I'll butt in there, Manjo. No, it's not, because judges have tenure, and for anyone to put a judge into any position, it has to be based on the tenure which is listed in the Constitution. It's Nicholas, by the way, just in case you're wondering.
Thank you, Nicholas. So sometimes the problem with Zoom is that there are 2 or 3 students who end up opening their mics, and it doesn't really tell me who's actually speaking. I have a sense because I can identify Gordon's voice by now, even Jason's voice. But sometimes, I can't. So it's a good thing you've identified yourself. So thank you, Nicholas. That is the correct answer. So there's a requirement under Section 72, for example, of the Constitution that there should be security of tenure. And because a justice has been appointed on an acting capacity does not have security of tenure. And that's right. Okay. So let's go to discussion question 2. Can I have a volunteer to read a question for us?
Sure, I'll volunteer.
Thank you. Who's that?
Sarah.
Sarah. Thank you, Sarah.
In Harrison Calladine, the High Court validated the power of the Family Court of Australia under the Family Law Act 1975 to make rules of court delegating to the registrars all or any of the powers of the court, except those relating to the dissolution or annulment of marriage and the custody of children. subsequently, Parliament passed an mandatory law that authorised the Family Court of Australia to delegate the registrars the power to decide on the dissolution or annulment of marriage, subject to the power of the Family Court to review the decisions of the registrars on both questions of fact and law, rule on the validity of such a law.
Thank you, Sarah. Any volunteer?
Well, I'll volunteer again.
Yes.
I wrote that the law would be valid as long as 3 conditions are met, and that's that judicial power should continue to reside in the court rather than a delegate, which it is.
Mm-hmm.
The court retains the power to review both questions of law and fact, which was stated as one of the conditions, and the delegate must act judicially.
Okay. Thank you, Sarah.
That's not stated, but as long as that happened, then I think the law would be valid.
Thank you. What do the others think? So that's a good argument you made. What do the others think?
Well, based on the reading in the book, Manjo, the answer would be yes, it would be valid, because that's pretty much what is said where it was challenged, and the High Court accepted the fact that as long as the registrars are still subject to judicial oversight by a judge, then any decisions that they make, because it's within the family law system, and it can be reviewed by a judge, then it would be constitutional.
I'm a bit concerned that the registrar, and I'm not sure about this, so I'm just having a bit of a stab in the dark, may be employed under the executive, and therefore there might be a breach there. Thoughts on that?
Mm-hmm.
Come on, Manjo, just give us the answer. You look at it as though we're half there and not quite there.
I've got a question does anyone know of instances, or are you aware of registrars actually making decisions as to the dissolution or annulment of marriage or the custody of children, where it is the registrar himself or herself who makes the decision in the court?
Yeah, I am, Manjo. It's John.
John?
Yeah. So I've got some experience in the Federal Circuit Court, and registrars are generally the ones who hear divorce cases, for instance.
Yes.
And most divorce cases are heard in chambers by registrars. They're not heard in open court, and it's basically just done on the paperwork, on the file. And parties don't generally have to appear. So, so that's generally the case. And judicial registrars are not uncommon in state jurisdictions either, where registrars of the court act in a judicial role rather than an administrative role. And it's become increasingly common in state jurisdictions, in Victoria in particular, because there's been a huge growth in the number of cases in the magistrates' court, and rather than appointing more magistrates, they appoint judicial registrars to deal with simple, minor cases and simple cases.
Thank you, John. Okay, do you mind if I step in before things become confusing? So thank you, John, for your observation. Let me just address that second point about state courts. So in this particular scenario, we will, it's probably difficult to derive important rules as far as state courts are concerned, because there is no separation of powers in the state courts. So in other words, it's really permissible for judicial power and even non-judicial power to be vested in non-judges. That's fine. It's a different case altogether as far as the federal judiciary is concerned, because of the Boilermakers case, where the High Court has emphasized that it is impermissible for non-judicial power to be vested in non-Chapter 3 courts. And obviously, registrars are not really part of the Chapter 3 court. And secondly, it is impermissible for judicial power to be exercised by non-Chapter 3 courts. Or was I saying the same thing? May have gotten confused there. So as far as the Boilermakers case is concerned, it is impermissible for non-judicial power to be vested in Chapter 3 courts, and it is impermissible for judicial power to be exercised by non-Chapter 3 courts. So those are the two key propositions of the Boilermakers case. In relation to the example of John, I think it's important to realize that in relation to divorce, for example, in the Federal Circuit Court, we might argue that what the registrar does is actually ministerial, because as far as Australia is concerned, because of the no-fault divorce law that we have, for as long as the parties, for example, have been separated for a year, then it becomes a matter of law. It becomes a right for the parties to actually be able to get divorced. So in that case, there isn't even a controversy to speak of. It just becomes a ministerial duty on the part of the registrar to actually grant the divorce. But let's speak, for example, of the custody of children. Okay, and so let's probably focus on that, because it might get confusing if we talk about annulment of marriage, mainly because of the no-fault divorce law that we have in Australia. As far as the custody of children, would it really be permissible for the registrar to adjudicate on it? My view is that it is not. Okay, so it is my view that it is not. If we examine the case of Harris versus Caladine, the justices there, Chief Justice Mason and Justice Dean, emphasized that it is crucial that in relation to the contested matters in a federal court, the major responsibility for the exercise of judicial power must still reside in the judges. So let me emphasize that. Chief Justice Mason and Justice Dean emphasized that the major responsibility for the exercise of judicial power must still reside in the judges. That is something that cannot be delegated. In fact, in the same case, Justice Brennan said that the power to decide controversies lies at the heart of judicial power. So because of this, I would argue, and this is the reason why even today you don't really see cases where it is the registrar adjudicating on the crux of the matter. It will be judges who will have to make decisions on the heart of the controversy. Peripheral matters, incidental matters, such as maintenance orders, for example, or property relations, for example, because these are considered to be peripheral, for example, to issues about custody of children, then perhaps it can be adjudicated by the registrars on the basis of Harris versus Caladine, but not as far as the contested matter itself. So we will notice that Harris versus Caladine, as well as Kotsis versus Kotsis or Cominos versus Cominos, in all of these instances, it was actually the exercise by the registrar of certain judicial powers was actually peripheral to the main controversy. So these were secondary matters. It wasn't the crux of the controversy itself, not the heart of the controversy itself. So I would therefore argue that this particular legislation would be unconstitutional. So just bear that in mind. Comments?
Can I just say, Manjo?
Who's that?
It's John again.
Identify yourself, because, as I said, it'll be easier if I know who's speaking. So
Yeah. In relation to the registrar, it's my understanding that registrars.
Speaking now. Sorry. Can you just identify yourself? John. Okay.
John.
There's a time lag, John, in your video. I couldn't know who's speaking actually. Okay. Thank you, John. Go on.
It's my understanding that registrars in the Federal Circuit Court don't act judicially in relation to custody issues.
Yes.
But I would argue they are required to act judicially in relation to divorce in particular, because there's certain criteria that must be fulfilled before they can make a decision on the case. And one of those is that arrangements have been made for any children of the marriage. And so they've got to be satisfied that if there are children of the marriage, that arrangements have been made for them before they will, before they'll basically approve the divorce. So, I would take the view then that requires some measure of judicial decision rather than just a purely administrative exercise.
Yeah, but the question, John, is in relation to divorces, for example, what actually is the controversy there? There's hardly anything for the parties to contest.
Well, yeah, that's right.
Because the moment there is proof that the parties have separated for a year, it becomes incumbent for the parties to be granted divorce. So
you can do it online too, isn't it, Manjo?
Yeah, you can even do it online. The parties don't even have to appear.
Yeah.
So I would argue that, so we really make a distinction between the exercise of judicial power itself, and that has to relate to the decision of a decision over a contested matter, which would be at the heart of the controversy, as opposed to something that's incidental. So we make that distinction. For as long as it is incidental, for as long as it is incidental to the exercise of judicial power, then it is permissible to vest judicial power in non-Chapter 3 judges, like the registrars. But
Manjo, I was going to say the answer to that that whole resolve is actually in the Family Law Act in 37A.10, because it clearly describes exactly what the registrars can and can't do in the way of dissolvement of marriage and children. 37A.10 is as clear as it gets.
What did he say? I'm not teaching family law. If he could tell us.
Sorry, what was that question, Manjo?
Can you tell us what the law says, 37A?
It's 37A.10. No, I don't have it in front of me at the moment, but I've put that down in my notes from reading during the week. So.
Okay, very good. Okay. So are we clear about that? We make a distinction between what is at the heart of the controversy, the contested matter, as opposed to something that's incidental. So if it is incidental, then it is permissible for judicial power to be vested in non-Chapter 3 judges. But if it is the contested matter itself, if we follow the requirements of the Boilermaker's case, then judicial power can only be exercised by Chapter 3 judges. Okay, now, having said that, hang on, what's going on with the no here? I see a no from Leticia and no from Leonie. What are those about?
That was you asking us whether or not they could rule on the custody orders of children.
Okay. Thank you. Now, so let's backtrack a bit. Why was it that the court in Harris versus Caladine said that it is permissible for the registrar, who is not a judge and therefore not part of a Chapter 3 court, to perform some judicial functions? Can we just clarify that?
Yep, I've got it now, Manjo. 37A.10,
yes.
provided that the court may, on application or on its own motion, review an executive or power by a registrar pursuant to the delegation, and importantly, this power of review was considered to include the power to review de novo the decision of the registrant.
Yes, that's right. So again, we're not speaking there of the custody of children, we're just what is that section about? Is that pertaining to divorce? Not custody of children, is it, Nicholas?
It's to divorce and the custody of children. 37A.10.
Okay.
But wouldn't it be, if it's Angelina? Sorry, Manjo.
Go ahead, Angelina.
If the judiciary have the right to review a decision at their own discretion, then essentially the decision that the registrars are making isn't a binding and authoritative decision. And if it's not a binding and authoritative decision, then essentially they aren't acting in a federal judicial manner.
So what would your position there be?
Well, then if they're not acting, if they don't have the authority to make a binding and authoritative decision, then essentially they're not really making a federal, they're not exercising a federal judicial power.
Therefore,
that it is constitutional because the judges can still overrule it.
That's right. So there are just two counter arguments I'd like to make in relation to that. So the first point is that we need to remember that as far as the Boilermakers case is concerned, the High Court has been very clear that judicial power can only be vested and exercised by Chapter 3 courts. So in other words, the exercise by registrars or non-Chapter 3 judges would have to be an exception to the Boilermakers case. So that's one thing we have to be clear. It is the Boilermakers case which is the case that emphasizes the rule that judicial power cannot be vested in non-Chapter 3 judges. And we know that registrars are not Chapter 3 judges, and they're not covered by the rule on security of tenure, according to Chapter 3 of the Constitution. So that is an exception. Now, having said that as well, we need to remember again the decision by the High Court in Harris versus Calladine, where although the High Court sanctioned the delegation of certain judicial power to the registrar, these were actually in relation to incidental matters. For example, pertaining to the annulment of marriages at the time that it could be argued that the state of the law was different. It wasn't about the heart of the controversy itself. And in fact, as I pointed out, Chief Justice Mason and Justice Dean, as well as Justice Brennan, pointed out that it is important that the major responsibility for the exercise of judicial power must still reside in the judges as far as contested matters are concerned, even though they had said that in relation to Harris versus Calladine, it is the judges who must still have the ultimate responsibility to oversee and review decisions and orders that are made by the registrars. So the three justices, Chief Justice Mason, Justice Dean, and Justice Brennan, emphasized the need for the judges to retain the exercise of judicial matters in relation to the contested matter of a case. And so therefore, I would argue that it is difficult to therefore extend the exception to the Boilermakers case to say that it is permissible for the Parliament to vest the judicial power in the registrars themselves, because that would be an exception to the Boilermakers case. Okay, would that be all right? Okay, I'm not going to be able to read Rin. I'll have a look, Rin, at what you've said there in a short while. I just wanted to ask that question again. So going back to the case of Harris versus Calladine, because the Boilermakers case emphasized that judicial power cannot be vested except in Chapter 3 courts, how is it that the court in Harris versus Calladine agreed that it was constitutional for the Parliament to vest certain judicial powers to the registrars who are not Chapter 3 judges? Why is that?
Isn't that because they only vested a certain amount of power on them to decide annulments that not dissolve a marriage? Is that right?
Yeah, so that's the reason. For as long as it is incidental to the exercise of judicial power, then according to the case of Harris versus Calladine, that would be permissible, for as long as it is not the actual contested matter itself. So there is a limit there. For as long as there's a review and it is not the main controversy itself, then Harris versus Calladine has authorized such a delegation.
Manjo?
Yes. Ilonka.
Yes, sorry. I just want to see if I understand this right. So the registrar in the family court, let's say, for instance, that you've got two parties, they've been separated for a year, they have agreed to a custodial agreement relating to the children. None of them is contesting that. The registrar can let this divorce go through. But the minute that there's any controversy, say they don't agree to the custody agreement, then that's referred to a court. that the gist of it?
Therefore, you go through the trial, and therefore there is a trial that goes on. Yes, go on.
Yep. No. That's just what so the registrar has a cutoff point to where they can actually intervene at all.
Yes.
Is that right? Okay.
So imagine a scenario where you have a trial in relation to custody of children. Okay, in the family court. Let's imagine that scenario. Would it be permissible for the registrar to adjudicate concerning the custody of the children, assuming that Parliament vests such power in the registrar? The answer is likely to be no, because that is the contested matter. So can you see the distinction there? So prior to that, if it is uncontested because the parties agree to have a consent order, that is fine. Anything peripheral to that, maintenance orders, support for children, again, that is peripheral to the contested matter. According to Harris versus Caledine, you can vest that. You can vest part of the judicial power in the registrar. But if the custody itself, if the matter related itself to the heart of the controversy, which is custody over the children, it would be unthinkable. It would likely be unconstitutional and invalid for the Parliament to vest that power to make the decision in the registrar himself.
So what you're saying, Manjo, it's Nicholas. The bottom line is, if there's a controversy of any kind, then the registrar has no ability to do anything. It has to go into the court.
I did not say that it's controversy of any kind. It is the final controversy. So if it is the final contested matter, I would argue then that should go to, that can only be decided by the judges. Because
well, that's interesting, Manjo, because a lot of the time it doesn't go straight to trial anymore under the Family Law Act. They push them through interim hearings, yes, which is a hearing that, and then what's done from that hearing and what decisions the judges make then. The judge can then decide to pass on what's written up and how it's concluded after that to a registrar do that work on his behalf. And it's still not concluded. That's
right. But again, you will notice that is not really contested and that is not the final controversy. But if it goes to trial, as part of the Elanca, that's kind of the cutoff point. If it goes to trial and the court has to make a decision, it is only the judge who has the power to exercise the judicial power about that final controversy. It can't be delegated to the registrar, even if the judge will exercise the power of reviewing a decision by the registrar, because that is the contested matter. And I use the concept of contested matter according to its usage by Chief Justice Mason and Justice Dean in the case of Harris versus Caledine.
Yep, I got you, Manjo. I agree. I can hear what you're saying, and I agree with you. It's very interesting that it no longer goes though directly to trial, and we've got an issue in the family court with people being pushed into interim hearings before it goes to trial, which is an issue within itself.
Okay, so I'm not gonna get caught up in the family law issue because I just wanted to focus on the constitutional aspects of these particular facts, and we're just using the backdrop of the Family Law Act for the purpose of elucidating certain constitutional law principles. Now, moving on in relation to this one, the other question that I asked earlier at the start of the tutorial was whether or not it was permissible for a Chapter 3 judge to undertake non-judicial functions in the course of dealing with a matter. So, for example, a law may say that in relation to custody of children, the judge may make such orders in relation to maintenance or custody of children in any manner that he sees fit, or whatever might be expedient or necessary according to the circumstances. Okay, now, so just to cut it short, those are examples of non-legal standards. And these are standards usually given to administrative decision makers, and which require the use of discretion. And for that reason, the examples I gave would constitute the exercise of non-judicial power. Okay, so the question is, would it be permissible, therefore, for a law, for example, that says that the judge may make such orders as it sees fit or is expedient according to the circumstances. Given that, that seems to involve the exercise of non-judicial power by a judge. Now, we will recall that according to the Boilermaker's case, it is impermissible for non-judicial power to be vested in a Chapter 3 court. What do you think? Again, related to the case of Harris versus Caledine.
Are you talking about in a Chapter 3 court right now?
Yeah. So the example I gave was that assuming that a law is passed, let's assume, it's in relation, for example, to the Family Law Act, 1975 Commonwealth. I'm not very clear about what the provision is, but let's assume that an amendment to the Family Law Act 1975 provides that the judge shall make such orders as he sees fit or is expedient or necessary under the circumstances. Now, those would involve the exercise of non-judicial power because those are non-legal standards. So arguably, they involve the exercise of non-judicial power. The question is, if that were a provision in the law, would that provision be valid or not?
No, it would be invalid.
Mm-hmm. Okay.
I disagree. I'd say it would be valid as long as it's in line with the function of the court to do whatever administrative actions it needs to have the court continue its duty.
So that's actually the correct answer, the one said by Nicholas. So if you follow Harris versus Caledine and Kotsis versus Kotsis and Caminos versus Caminos, it is actually permissible for non-judicial power to be vested in Chapter 3 judges for as long as they are incidental to the main case. So because it is incidental to the main case, it is permissible for non-judicial power to be vested in Chapter 3 judges. Okay, was that clear? For as long as they're incidental to the main case. That's according to Harris versus Caledine.
So that's the key word, is it there, Manjo? Incidental to the primary case.
Yes, incidental to the exercise of judicial power. So that's incidental to the exercise of judicial power, which we know to mean that it is incidental to the heart of the controversy itself or the contested matter, which would involve the exercise of judicial power. Okay, clear? Okay, so let's move on. Question 3. Can somebody read the question for us? So things can get confusing because there's so many exceptions to the exceptions, and if you happen to have a question, just raise it, and I'll try to answer it if I can. Question 3. Can somebody volunteer to read the question? Just read the question.
I'll do the short version. In Cable and Farden, the High Court acknowledged the power of the state parliaments to vest non-judicial power on state courts. Following these rulings, the Commonwealth Parliament amended the Telecommunications Interception and Access Act 1979 Commonwealth to authorise any state court judge to issue interception and access warrants when it can be established by the state police officers that a serious crime is likely or about to be committed in the state. Rule on the validity of the law.
Thank you, Jason. Volunteers. So we have from Rin, it's not valid.
Manjo, it's Ilonka here. I think it's valid.
How do you pronounce your name? Sorry, how do you pronounce? Ilonka. Okay.
Ilonka, yep. I think that it is valid because this is at state level. Is there a separation of powers? Does that come into it at all?
Hang on. At the state level, there is separation of powers. Is that what you said?
No. I said at state level, there's not a separation of powers, and this is state courts, is it?
Okay. Let's leave it there for now. What do the others think? So according to Ilonka,
sorry.
Angelina?
I have a different answer. I don't think it's valid. On the basis that in Cable v DPP, it was established that Parliament can't use the fact that there's not a separation of powers in the Constitution to create laws or statutes that essentially just use the judiciary or police officers to do whatever they like. They're essentially creating laws to further their own cause without any real legal basis for it.
Okay, thank you, Angelina.
I think it's invalid too, because there's nothing in the Constitution that authorises the Commonwealth Parliament to vest state courts with state jurisdictions. Like, they can't tell the states what to do.
That's right. That would be the correct answer there. Okay. So the correct Jason, can you just repeat that for us, please, if it's all right?
Yeah, I had to practice that while everyone else was talking. There's nothing in the Constitution that gives the Commonwealth Parliament the powers to vest state courts with state jurisdictions. That's right. Their pay grade. They don't have the authority to do that.
Okay, so in this case, this is the Commonwealth Parliament vesting state courts with state jurisdiction. The Commonwealth Parliament has no power to do that. But the Commonwealth Parliament does have the power to vest federal judicial power on state courts. Okay, let me repeat. So according to Section 77 of the Australian Commonwealth Constitution, the Commonwealth Parliament has the power to vest federal jurisdiction in state courts. But in this case, it is the Commonwealth Parliament vesting state jurisdiction, not federal jurisdiction, on state courts, which is why Jason is correct. Only the state parliament can vest state jurisdiction on state courts. Now, there's another reason as well why this is invalid. What might that be?
Does it have anything to do with finding the state courts, or as they find them? Does that make sense?
Was that?
Sorry, that was Leonie.
Yes, go on, Leonie. Tell us about that.
I don't really... Maybe somebody has a grasp on it, has a better idea, but I just wondered if that's what I read today.
Yeah. You're right about that principle, although I'm not sure if that really applies here.
Okay.
But there is that principle that the federal parliament must take the state courts as it finds them. So it cannot reconstitute the state courts in order to suit the purposes or intentions of the Commonwealth Parliament. But the other thing I like to point out is that while the High Court has acknowledged the power of state parliaments to vest non-judicial power on state courts, the corollary is that the federal parliament also does not have the power to vest non-judicial power on state courts. So the federal parliament can vest judicial power, federal judicial power in state courts, but the federal parliament cannot vest non-judicial federal power on state courts. Can you see the distinction there? So Section 77 vests in the Commonwealth Parliament the power to vest federal judicial power on state courts. It does not vest in the Commonwealth Parliament the power to vest non-federal judicial power on state courts. That's something else. This one involves the exercise of non-judicial power. The federal parliament does not have the power to vest non-federal judicial power on state courts. So that's the other reasoning. Okay. Clear? Okay. Where are we now? Question 4. Can somebody read the question for us?
Right, I'll do it. In order to add certainty to the validity of certain high-value commercial contracts whose subject matter had a commercial value of $100 million or more, Parliament passed the Important Commercial Contracts Law, Commonwealth, under which the Federal Court of Australia has jurisdiction to review and make a declaration on the validity or invalidity of proposed high-value commercial contracts upon the joint agreement of all the parties to a high-value commercial contract. Rule on the validity of such a law.
Thank you, Angelina. Any volunteers?
Hi. Volunteer.
Christy, yes, please.
Hi, Manjo. I was thinking, is that permissible under Section 51, where the federal parliament's allowed to make laws about trade and commerce with other countries and among the states?
Okay, so if this were a final assessment question, you're right to raise that legal issue. Is it within the power of the federal parliament to pass this particular law? Is it within its head of power? That's one. Okay, that's right. But the other question is, assuming that the Commonwealth Parliament has the power to legislate on this subject matter, the question is, would it mean that it is now beyond question? No one can question its legality. So assuming that it is within the power of the Commonwealth to legislate on this subject matter, the next question is, does it mean therefore that the law is necessarily valid, or can it be subject to attack? And if it can be subject to attack, by what way can you attack the validity of this particular law?
Doesn't there have to be a controversy?
Very good. Go on, Gordon.
Well, in this case, they are saying that the passing a commercial contracts law under which the Federal Court of Australia has jurisdiction to review and make a declaration on the validity or invalidity of contracts. But there are no two parties. They don't have standing. There are no two parties that are in conflict here. It's a hypothetical.
That's right. That's right. So this would be an unconstitutional law because there is no matter. And judicial power can only be exercised when there is a matter. And we know that a matter is defined by Huddard Parker versus Moorhead as one that involves an actual controversy between parties, between individuals, between corporations, or between individuals and the state. So this is a hypothetical scenario. And the case of Re-Judiciary Act of, in the case of 1921, the High Court said that it would be impermissible, it would be unconstitutional for the federal judicial power to be exercised where there is no matter. So this would be an invalid law. Very good. Okay. Questions? There was
John.
Sorry, John. I'll go back to you quickly in a second. I'm just going to address Monique. She was asking if the weekly answers will be provided. I will post the answers to tonight's tutorial immediately after this session. I'll post them in Moodle. Okay, John, go ahead. Go ahead.
I was just thinking that, like in the example of an Attorney General's reference in the states courts, I'm not sure whether there's a Commonwealth equivalent where there's no actual parties to a case. It's just an issue that the government decides it needs to be settled in terms of the position of the law.
That's right. So the point is that the Attorney General is not part of the chapter, it's not part of the judiciary, it's part of the executive.
Yep.
So that would be the reason why, or the Solicitor General for that matter, that would be the reason why they can provide advisory opinion. And what we need to remember is that whatever statements are made by the Attorney General or even the Solicitor General in the course of trying to defend the actions of the government, whatever the Attorney General or the Solicitor General say, they do not constitute the law because only the courts are able to interpret the Constitution or the validity of certain laws.
Yep. Okay.
Thank you. Let's move on to question 5. Can I have a volunteer for the purpose of reading this particular question?
I'll read it.
Who was that?
Amanda, yeah. In order to add certainty to the validity of certain high-value commercial contracts, whose subject matter had a commercial value of 100 million or more, the New South Wales Parliament passed the important Commercial Contracts Law, New South Wales, under which the New South Wales Supreme Court has jurisdiction to review and make a declaration on the validity or invalidity of proposed high-value commercial contracts upon the joint agreement of all the parties to a high-value commercial contract, rule on the validity of such law.
What do you think? Talking to the entire class.
First of all, Manjo, who's contesting this if the whole thing comes down to a joint agreement by all parties?
Who's contesting it?
Yeah, I mean, who is contesting whatever possibly could be contested in the first place if all the parties are in joint agreement?
It could be one of the parties. So let's assume that at some point one of the parties disagrees with the contract that was entered into.
Okay, I have some thoughts on it, but I'm not positive if I'm right. So the state legislatures, they've got no obligation to adhere to the separation of powers, so they can validly vest non-judicial power in the state courts, as long as it's not repugnant to or incompatible with the exercise of judicial power. That's Cable and the DPP. But is it Wayno in New South Wales, they said the state legislature cannot confer anything which substantially impairs its essential and defining characteristics of the court. Now, this is kind of where it got me, that a defining characteristic of the judicial arm of government is its mandate to determine matters. And once again, we come back to the previous question of there is no matter. So you don't have the problem that we did in the previous question, so that the Parliament can confer power or jurisdiction on the court to determine an abstract question of law. But determining something that's not a matter, is that a defining characteristic? And therefore, according to Wayno in New South Wales, it will substantially impair the defining characteristic.
Comments from others?
It's John Manjo. This seems to be more an administrative review rather than a contested case.
More of an administrative review. Why is that? When it's the New South Wales Supreme Court that's involved?
Well, if there's no dispute and the parties they jointly agree, then it seems to be more an administrative review rather than deciding on a contested case.
I don't want to go into administrative law because it can get confusing for some. But looking at the constitutional law they mentioned here, really, as pointed out by was it Gordon? There is no controversy involved, so there is no matter. Yeah. And so therefore, if there is no matter and there is no controversy, the question really is it permissible for a state parliament to vest non-judicial power on a state court? That is the question. That is the legal issue.
And they can do that.
Because
there's nothing in the Constitution which states that the state, because of the sovereignty of the states, they are allowed to vest non-judicial power in the courts.
In state courts?
Yes, in state courts.
So that's right. So that's the correct answer there. Unlike in the federal judicial system, where there is a separation of power, and especially following the Boilermakers case, the High Court was clear that non-judicial power cannot be vested in a Chapter 3 court. There is no such equivalent at the level of the states because there is no separation of powers in the states, according, for example, to Cable versus Director of Public Prosecution. So therefore, it is permissible for the state parliament to vest non-judicial power on state courts. So an example of a non-judicial power would be to render an advisory opinion or to render an opinion in a situation where there is no actual controversy. So this is an instance when there is no judicial power, when there is a non-judicial power that is vested by the state parliament on a state court. That is valid because there is no separation of powers in the states. Okay, now let me just move it a bit because was it Sarah who pointed out earlier the case of Wainohu. So, assuming that there is no separation, not assuming, because we know that there is no separation of powers in the states. Okay, there is no separation of powers. So let's assume that the state parliament passes a law that a state judge in deciding a particular matter or non-matter, it must act according to directions or opinions made by an officer of the state. Okay, so let me repeat. There is no separation of powers in the states, as we know, according to Cable versus Director of Public Prosecution. So assuming there is a law, so I'm following the point by Sarah when she mentioned Wainohu versus New South Wales. So assuming that there is a law passed by a state parliament which says that a judge must act in a matter or a non-matter according to the directions of an officer of the executive, would that state law be valid, considering that there is no separation of powers in the states in the first place?
Manjo, it's Nicholas, and I'd have to say no, because the Supreme Court in that sense of any state is still part of the federal court system.
Mm-hmm.
And so a state legislator cannot override federal jurisdiction.
That's right. So that's the correct answer. And as pointed out by Angelina, you can't use state courts as instruments of the executive. And as pointed out by Ilonka, so you're all getting this now. The integrity of the judiciary is threatened, and state courts are actually part of the integrated federal judicial system. Well done. So that was the case of Wainohu versus New South Wales. So that whilst there is no separation of powers in the states, the state courts cannot be used as an instrument or an instrumentality of the executive or of the parliament. The state courts must still function independently, because otherwise the integrity of the judiciary will be threatened. So that will not be countenanced by the High Court. Okay. Questions, comments? That was actually the last tutorial problem that we have. Earlier, if there's no question, let me just jump a bit, unless you want to backtrack. So I was earlier raising the question about military tribunals who seem to be exercising judicial power. Is anyone here? Let's quit while I'm ahead from Ilonka. I'm just curious, we know that soldiers in the defense force, you've heard cases of some women in the Navy who were subjected to sexual harassment and so on. And they are investigated, tried, and even convicted by military tribunals. But the judges of military tribunals have not really been appointed according to Chapter 3 of the Constitution. In fact, military tribunals have not been constituted according to Chapter 3 of the Constitution. They don't have security of tenure, for example, and they can be removed according to whatever rules the defense force has. But they are certainly exercising judicial power. The question is that constitutional or valid?
Manjo, it's Ilonka again.
Yes.
Sorry, don't they have a court-martial system that's more disciplinary than judicial? Does that have something to do with it?
It can be said that there is potentially a matter that's involved. There is an actual controversy, because imagine somebody being subjected to imprisonment for 20 years. There is an actual controversy between the individual and the state. So there is a matter. So there is involved is the exercise of judicial power by the military tribunals. That's the point. It would appear that the military tribunal is exercising judicial power of the Commonwealth, because it is involved in matters where there is an actual controversy between an individual and the state, especially when it comes to criminal prosecution and criminal punishment. So my question is that valid or not? Or why is it happening?
Isn't that something, it's Nicholas Manjo, isn't that something to do with the fact that military and application of military are subject to federal law?
Okay.
And so the federal parliament, who has control of the military, literally is giving authority to the military to create tribunals, and in its essence, its own written constitution on how to deal with matters inside the military.
Okay, but we will recall that even Section 51 of the Constitution, which recognizes the legislative power of the Commonwealth, provides that the powers of the Commonwealth can only be exercised according to the Constitution. And according to the Constitution, judicial power resides in the federal judiciary, and military tribunals are not part of the federal judiciary, and yet they seem to exercise judicial power. So that would contravene the Boilermakers case, where the High Court said that you cannot vest judicial power except in Chapter 3 courts. Now, military tribunals are not Chapter 3 courts. So it would appear that if the federal parliament were to do that, they're clearly contravening the Boilermakers case. So how is that?
If the military are the ones bringing about the ones that are adjudicating, and they're the ones bringing it to their tribunal, then could it be said that they're acting on their own merits? That they're acting, on their own
power?
Like it's, I know what I'm trying to say. That they're bringing the matter, that they're the ones that are bringing the matter, that they're not adjudicating on a controversy between two parties. They're doing it on their, so I've got the word somewhere. I
think
of their own thing.
I think we can agree that the military tribunals in many cases are actually adjudicating on a matter, because there is an actual controversy between an individual and the state. Imagine an individual who would most likely be imprisoned. So they are exercising judicial power. The question is, how is it that these military tribunals seem to be exercising judicial power contrary to the principle of the Boilermakers case? That is my question there. It's perplexing. Why?
Hi, Manjo. It's Christy here.
Yes.
Are they permitted to do that because it falls perhaps under the exclusive power of Parliament in Section 52 of the Constitution?
Which is?
Parliament shall, subject to the Constitution, have exclusive powers to make laws for the peace, order and good government of the Commonwealth in respect to certain matters. And then subsection 2, matters relating to any department of the public service. And because the military is arguably part of the public service, it's a public department, is what the military tribunal's doing valid because of that section?
If we follow that argument, then it can be said that it would also be valid for the Parliament to vest non-judicial power, to vest judicial power in administrative tribunals, following that argument, because they belong to the public sector. But we know that even Section 51 and Section 52, the exercise of parliamentary powers, federal parliamentary powers, must be according to the Constitution, which means that would run afoul of the Boilermakers case still. Anyway, the point there is, because it's past 7 now, the point is, what's interesting is that in the case of Queen versus Bevan, ex parte Elias and Gordon, the High Court recognized that military tribunals indeed exercise judicial power of the Commonwealth, but it's not a result of the Constitution. They sit outside of the Constitution. So military tribunals are sui generis. They're a distinct breed of their own, recognized historically and by the need for the operational efficiency of the military and the defense to act expediently and quickly in relation to defense of the Commonwealth. And so therefore the High Court has arrived at a what Ratnapala and Crow argued to be a contrived reasoning that whilst the military tribunals are exercising judicial power of the Commonwealth, that judicial power is not coming from the Australian Commonwealth Constitution, but sitting outside of the Australian Commonwealth Constitution. So it is distinct. It is sui generis.
So where does it get its power ultimately from then?
It is a matter of historical recognition, because even in the US, it is recognized that in the US military tribunals sit outside of the US court system. Secondly, as a matter of operational efficiency, it is recognized that it is expedient and necessary for the military tribunals to be given that power. So, as argued by Ratnapala and Crow, from a theoretical point of view, it doesn't make sense. But it is what the High Court has said, that whilst military tribunals are exercising judicial power of the Commonwealth, it is not as a result of they sit outside of the Australian Commonwealth Constitution. So that is why, as I said, it can get tricky when it comes to constitutional law, because the judges of the High Court may not be addressing certain legal issues. They just may arrive at a particular decision without regard to certain constitutional law principles, or whatever they say is the law. Okay, so it's 7:08.
Manjo, sorry, I just have a question on that. So if you are tried in the military court then as such, you can't go to the High Court in appeal? Is that effectively what it means?
Very unlike, no, not on appeal, because remember, appeal is a matter of the statute, of whatever the Parliament provides. So appeal, remember, is a common law right. It is not a constitutional law right.
So that part of it doesn't fall outside the Constitution. You still have the right to go to the High Court, even though the matter was...
I don't want to use the word appeal. Okay. The question is there recourse to the High Court? Is there a legal remedy that enables somebody from the military to go to the High Court?
Yes, that's what I mean.
Question. Okay.
Yeah.
There is Section 75 of the Australian Commonwealth Constitution where in matters where the High Court has original jurisdiction in all matters where there is a request for the issuance of a writ of prohibition, mandamus, or injunction against officers of the Commonwealth. Arguably, therefore, on that basis, remember, military tribunals are officers of the Commonwealth. That can be a basis for recourse to be given, to be brought to the High Court, only in those specific instances, prohibition, mandamus, and injunction, and purely on a question of law, not on a question of fact. So in other words, if somebody is questioning the correctness of a decision of the military tribunal because the accused, who is a part of the military, disagrees with the findings, you can't bring that to the High Court because it has to be on a question of law. Okay, so there's that remedy, Section 75. Okay, so we've exceeded our time. Oh, there's a case there from Lane versus Morrison, 2009, Amanda Smith. I'm going to have a look at that. I'm not familiar with the case. Thank you, Amanda, for flagging that for us. I'll have a look at that. So thanks, everyone, for participating in tonight's session. And if you have any questions, please feel free to send me an email. Preferably post it on Moodle if it's something that's relevant to everyone else. And with that, I hope to see you again next week. Good night. Bye.
Can I just ask a question of you? I sent an email during the week. Have you looked at it?
When did you send it, Leonie?
Possibly.
Yesterday. You sent me an email yesterday. I haven't responded to it. I was hoping to do so tonight. If not tonight, tomorrow morning. Okay. Thank you. Have a good week, everyone. Bye.